judgment, Her Royal Highness, the Duchess of Sussex and Associated Newspaper Limited.
So for the reasons given in the judgments we have today handed down, this appeal will be dismissed. And what I propose to do now is to read out a summary of the judgment, a short summary, so as to explain to the press and to the public what we have decided. It should be noted, however, that this summary forms no part of our decision, but it's just provided for information and the better understanding of the decision. The central question in the case was whether the judge, then Mr. Justice Warby, now Lord Justice Warby, had been right to grant summary judgment for breach of privacy and breach of copyright to Meghan, Duchess of Sussex, against the publishers of the Mail on Sunday newspaper and Mail Online, Associated Newspapers Limited. The claims related to the publication in the Mail on Sunday and the Mail Online, I'll call them together Mail on Sunday, of about half the contents of a 5-page handwritten letter, which I'll call the letter, which the Duchess had sent on the 27th of August 2018 to her father, Mr. Thomas Markle. The Court of Appeal upheld the judge's decision that the Duchess had a reasonable expectation of privacy in the contents of the letter. And those contents were personal, private, and not matters of legitimate public interest. The articles in the Mail on Sunday interfered with the Duchess's reasonable expectation of privacy and were not a justified or proportionate means of correcting inaccuracies about the letter that had been contained in an article published on the 6th of February 2019 in People magazine in the United States. The key point was that the Mail on Sunday articles focused on revealing the contents of the letter rather than providing Mr. Markle's response to the attack on him in People magazine. The headline was "Revealed," the letter showing true tragedy of Meghan's rift with a father she says has broken her heart into a million pieces. And the first line of the Mail on Sunday article read, "The full content of a sensational letter written by the Duchess to her estranged father shortly after her wedding can be revealed for the first time today." Those passages demonstrated that the Mail on Sunday articles were splashed as a new public revelation of extracts from the Duchess's letter to her father, rather than her father's answers to what People magazine had written. Associated Newspapers argued that the judge had failed to realize how People magazine had traduced Mr. Markle by alleging that he had cold-shouldered his daughter at the time of the wedding, lied about her shutting him out, and ignored her pleas for reconciliation in a loving letter. The Court of Appeal found that the judge had been right to decide that just one paragraph of the letter could have been justifiably deployed to rebut the allegation in People magazine that the Duchess's letter was loving, when in fact it was not. It was a letter reprimanding Mr. Markle for talking to the press and asking him to stop doing so. The Court of Appeal rejected Associated Newspapers' arguments that the judge had firstly applied the wrong legal test in deciding where the balance lay between the Duchess's Article 8 rights in the letter and the rights of Mr. Markle and associated newspapers to freedom of speech under Article 10. Also, the Court of Appeal rejected associated newspapers' arguments that the judge had failed properly to evaluate associated newspapers' defences to the Duchess's breach of copyright claim. First, fair dealing in reporting current events, and secondly, the public interest in reporting the letter. It had been common ground that the judge had correctly stated the legal principles that were applicable to the question of whether summary judgment should be granted. The Court of Appeal commented that the new evidence that had been provided to it had also been widely publicised in the press nationally and internationally. And in those circumstances, the court decided that the new evidence should be admitted as a matter of pure pragmatism, even though it was more directed to the drafting of the letter and to what the Duchess knew about the contacts between the Kensington Palace communications team and the authors of a book, Finding Freedom, than to the issues in the appeal. Despite actually finding the evidence, the new evidence, of little assistance, the Court of Appeal noted that the Duchess had apologised to the court for the pleading served on her behalf that said she did not know if and to what extent the communications team were involved in providing information for the book. It had appeared from new evidence from Mr. Knauf that he had provided some information to the authors of the book with the Duchess's knowledge. The Court of Appeal said that this was at best an unfortunate lapse of memory on her part, but did not bear on the issues and had been given no prominence in associated newspapers' oral argument. So for the detailed reasons given in my judgment, the judge's careful decision, mostly on factual questions, was upheld, and it was hard to see what evidence could have been adduced at trial that would have altered that situation. The judge had been, we found, in as good a position as any trial judge to look at the article in People magazine, the letter itself, and the Mail on Sunday articles to decide if publication of the contents of the letter was appropriate to rebut the allegations made against Mr. Markle. The judge had correctly decided that whilst it might have been proportionate to publish a very small part of the letter for that purpose, it was not necessary to publish half the contents of the 5-page letter as associated newspapers had done. The court reiterated in conclusion the narrowness of the issues that it had had to decide. So that concludes the summary. All consequential matters will be dealt with in writing after today in the usual way. Unless counsel have any submissions they'd like to make about that, that concludes this short hearing.
No submissions from me, my lord.
Nor from me, my lord.
Thank you, Mr. Caldecott.